When served with a complaint, a person can either 1. File a motion to dismiss under the relevant federal or state court rules, or 2. Draft an answer to the complaint. If one decides to answer the complaint, several rules should be followed to ensure that the answer accurately responds to the allegations in the complaint, asserts all relevant affirmative defenses to the legal claims in the complaint, and sets forth counterclaims and cross-claims, if applicable. We will discuss the importance of 4 steps. 1. To review the local rules in the jurisdiction. 2. To research the legal claims asserted in the adversary's complaint. 3. Respond to the adversary's factual allegations. And 4. Assert affirmative defenses, counterclaims, cross-claims, and third-party claims. Number 1. Review the local rules in the jurisdiction. The local rules may contain additional requirements that govern the filing of an answer. These requirements may include whether one can assert a general denial of all factual allegations, or whether he must respond to each allegation individually. In many instances, the local court rules will contain requirements that will not necessarily be found in the federal or state court rules. For example, a judge in the Eastern District of New York may require that an answer be filed using a particular font and font size. Number 2 is to research the legal claims asserted by the adversary's complaint. Before drafting an answer, one must be sure to research the adversary's legal claims. Doing so will help determine whether one can assert specific affirmative defenses, counterclaims, cross-claims, or third-party claims. Conversely, by failing to perform sufficient research, one may inadvertently fail to identify defenses that could have led to the dismissal of the complaint, or resulted in a substantial reduction in the damages to which the plaintiff might be entitled. For example, let's say a plaintiff alleges in a complaint that the defendant was negligent in maintaining his business's parking lot by not clearing it of trash or debris. When exiting his car, the plaintiff slipped and fell on a piece of trash and broke his leg. The complaint does show, though, that the plaintiff was found to be intoxicated when exiting his car before slipping on the piece of trash. The plaintiff seeks to recover his medical expenses as well as damages in the forms of lost wages, pain and suffering, and emotional distress. Now, if the defendant or his attorney took enough time to research the adversary's legal claim of negligence, he may realize that one of his potential defenses is a claim of comparative negligence. Comparative negligence provides that a claimant's recovery may be reduced if the claimant's own negligence contributed to the damages. When reviewing the facts in the example, it's highly possible that the accident was due, at least in part, to the plaintiff's intoxication. By taking the time to adequately research the legal claims in the complaint, the defendant will learn how to successfully counter some of the complaint's arguments. Let's now take a look at responding to the factual allegations in the complaint. Typically, one must respond to every factual allegation in the complaint by 1. Admitting the truth of the allegation, or 2. Denying the truth of the allegation, or 3. Partially admitting and partially denying the truth of the allegation, or 4. Lacking the information to state whether the allegation is true or false. The responses must be accurate and made in good faith. General denials, like denying every allegation in the complaint, are highly disfavored and, even when allowed, may negatively affect an individual's credibility with the court. Additionally, the responses should typically be limited to 1 sentence. Explanations are not necessary and may prejudice a client by revealing harmful information or litigation strategy. For example, one should not deny allegations that one knows or should know are true. Such denials will negatively affect that person's credibility with the court and cast doubt on the credibility of the other responses. Let's look at some examples of adequate, accurate, and good faith responses to specific factual allegations. These examples are all allegations and potential responses using the fact pattern we discussed earlier about the plaintiff who injured himself in the defendant's parking lot. Let's say the first allegation is that the plaintiff's principal place of business is located at 250 Fifth Avenue in New York, New York. A response might be, defendant admits the allegation contained in paragraph 1 of the complaint. This, of course, would be appropriate if the defendant knows this to be the correct address. Let's say the second allegation is that defendant failed to take any steps to remove the trash and debris that had accumulated in the business's parking lot. A potential response to this allegation might be, defendant denies the allegations contained in paragraph 2 of the complaint. Of course, this should be denied only if the client did make at least some attempt to remove the trash and debris. Let's say the third allegation is, quote, Well-known empirical studies demonstrate that negligently maintained parking lots increase the likelihood by 64% of accidents resulting in severe injuries. A potential response to this third allegation might be, quote, defendant lacks sufficient information to admit or deny the allegations contained in paragraph 3 of the complaint. This response should be given if the defendant is unaware of these studies or unaware of the validity of these studies. Now let's turn to affirmative defenses, counterclaims, cross-claims, and third-party claims. When drafting an answer, you should assert all defenses that you may have in response to the factual allegations and legal claims. Also, based on events that gave rise to the adversary's complaint, one may have a cognizable legal basis upon which to assert counterclaims, cross-claims, and third-party claims. Counterclaims means legal complaints seeking damages by the defendant against the plaintiff. In essence, the defendant is turning the lawsuit around and countersuing the plaintiff. Cross-claims are complaints against other parties that are already in the litigation, usually parties that are also named as defendants. Third-party claims are new claims against parties who are not yet part of the litigation. Essentially, these claims bring them into the litigation. All of these should be asserted, if at all, in the defendant's answer. If the defendant failed to do so, the defendant may later be able to amend the answer to include these cross-claims, counterclaims, or third-party claims. One can assert multiple defenses without needing to explain in depth why those defenses are being asserted. Instead of asserting as many defenses as possible, though, one should focus on identifying defenses that have a reasonable likelihood of success at trial. After researching the legal claims asserted by the complaint, you should include all affirmative defenses that have at least a chance for succeeding on the merits, but should not assert frivolous defenses. The answer should state in short and plain terms the defenses to each claim asserted. Going back to our example from before about a plaintiff who slipped and injured himself in the defendant's parking lot, the defendant can potentially assert several affirmative defenses. Each of these affirmative defenses takes the plaintiff's allegations into consideration, is simply stated, and has at least an arguable chance for succeeding on the merits. Here are some examples of affirmative defenses. 1. Plaintiff has failed to state a claim upon which relief can be granted, and plaintiff's claim should be dismissed. 2. Plaintiff, by virtue of being legally intoxicated, was comparatively negligent, and thus liable for the majority of damages alleged. Drafting an answer is a critical component to a person's defense when sued. Even though it may initially seem daunting to respond to each of the plaintiff's allegations, one who follows these guidelines and recommendations can counter this threat and draft a responsive and effective pleading.